released on reasonable bail or bond terms, pending a charge or a trial, unless there are compelling reasons not to. But this court also should take judicial notice of the term compelling reasons is not defined by the Constitution. So what happens if this term is not defined under the Constitution? It is left to judicial interpretation. I do not want to try and define this judicial interpretation, but compelling reasons, put it simply, means a convincing argument. The work of the applicant today is to put forth a convincing argument that would warrant this court to give them orders as have been sought in the application of the 25th. Our submission, Your Honor, is that there are no compelling reasons or convincing arguments that have been put forth in support of this application. I'll try to assist even the applicants to some of the compelling reasons that are usually advanced by the prosecution for the applicants. So, firstly, there is no evidence that has been put forward by the applicants to show that the respondents have a capacity to influence. If you look at the application that is before you, Your Honor, more particularly, there's these two paragraphs which were referred to you. At paragraph 9 of the supporting affidavit, the applicant states that there is a very high likelihood that the respondent, it doesn't tell us which respondent, just says that it's a respondent. And you know, Your Honor, parties are bound by their own pleadings. They don't tell us which respondent would likely interfere with this investigation. Our submission is that, save for that paragraph saying that there is a very high likelihood that the respondent will interfere, there is no compelling evidence that has been annexed to that paragraph, say in terms of evidence that can compel this court to grant those orders. It is just a blanket statement that has been put there. The second issue is that the applicant indicates that there is a likelihood that the respondents, more importantly the second, third, and fourth respondents, although it cuts across all the respondents, are flight risk. The same, there is only a blanket statement that has been made in the application. There is no supporting evidence to back up that blanket statement that has been made in the application. More importantly, the application refers to a respondent. It doesn't say respondents. I refer the court to ground number 8 in support of the application, and number 9. They refer to a respondent. We don't know which respondent. So I believe in our submission that paragraph does not refer to either the second, third, or fourth respondents. It could be the respondent who's not before this court. If you look at the application, they indicated that there is one suspect who's still at large. It could be that this respondent referred to yes. The third submission that we should make is that the seriousness of this offense in itself does not make it a compelling reason to warrant that the respondent not be admitted to, reasonable bond and, bail terms. The assertion that by the prosecution that this is a public interest matter, which assertion is not even in the affidavit or the application itself, also does not make this matter, or is not a compelling reason in itself to warrant this court to grant the orders or not to grant reasonable bail terms to respondents. Your Honor, from time to time, Article 49...
That one from taking photos, the views and media personality, is a guy standing up there with a mask. Kama si wa media, asipige picha. Akuchukua hiyo simu mwani. This procedure.
Our humble submission is that, save for these blanket statements which are being made by the applicants and the prosecution, there is no evidence that has been brought forth. I've had an assertion being made that these are very popular individuals who are likely to interfere with the investigations. Save for that statement, there is no evidence that has been coupled up to support that assertion. It would be even important if at least they would even attach an Instagram account showing that they have so many followers. But I mean, the applicant has, done nothing to, impress upon this court to warrant the grant of such orders. Your Honor, from time to time, Article 49, Article 1H has been abused. That is, as is read together with, that is Section 36 of the CPC. It has been abused by the applicants from time to time. And I think it's high time that we rewrite the judicial precedents around the application of this article. Your Honor, that's my humble submissions on that issue. I'll let my colleague Mr. Biro maybe highlight other issues of the second part of this one.
Thank you, Your Honor. Your Honor, before I proceed, I would like to pass a message of condolence on behalf of the respondents. We wish to commiserate with the family, friends, colleagues and relatives of the deceased. Your Honor, number two, my learned friend for the first respondent has requested me to mention that the media that he meant was not the mainstream media, the one that is on the rumor mongering, but the classical media. So that should go on record that he didn't mean our good friend from the Fourth Estate. Having said that, Your Honor, having said that, Your Honor, as a judicial officer, we have noticed in the recent past that it has become customary and maybe...
You said as a judicial officer, you are saying?
Yes, ma'am.
You are a judicial officer?
Officer of the court. My lady, the brain suddenly becomes stale as the day ages. It has become customary and to a certain extent fashionable for the prosecution without tying a number to approach the court with miscellaneous applications praying for custodial orders. Your Honor, this honorable court is faced with an opportunity to stop this type of practice that is creeping its head in our courts. You are being called upon to make a determination based on what is called an affidavit. You are being called upon to make a determination based on storytelling. Headline affidavit. There is no evidence that has been annexed onto this document. Big words have been thrown. Some people have been called influential. Another word called flight risk has also been thrown into the document. But my lady, there is no iota of evidence that is attached to this document. There is a witness who has produced the so-called supporting affidavit. And he has gone ahead to whip this honorable court's emotions by saying that they need more time to produce the remaining part of a post-mortem. But there is no remaining part of a post-mortem. There is only one document, an autopsy report. And that document is conclusive because it is carried out by a registered pathologist. And as they say, Your Honor, medicine is an exact science. And therefore, that is a document that cannot be controverted by anyone. Yes. Your Honor, you have also been treated to another issue of witnesses, and a request has been put to you that they need more time, specifically 21 days, to interview more witnesses in Kikuyu. No specific number has been brought to you on the number of witnesses that need to be interviewed. The census report of 2019 captures the population of Kikuyu as 323,881. 323,881. The prosecution wants to interview all the 323,881. I don't know how feasible that is. Your Honor, my learned friend, Mr. Nyamumbo, has mentioned Article 49(1)H, and I wish to reiterate this, that article confers a right to every arrested person to be released on bond pending trial. And it goes on to say, unless there are compelling reasons. Your Honor, we all appreciate that that right is not absolute, but limited by existing compelling reasons. Your Honor, if you allow me, I would refer you to the Oxford Law Dictionary, where compelling reasons is defined as powerful, evoking attention, or admiration. Your Honor, the prosecution has not demonstrated any cogent evidence that would convince the court that if admitted to bond, then the second, third, and the fourth accused persons, herein referred to as the respondents, are likely to abscond or involved in acts that would undermine the administration of justice. Your Honor, you have also been treated to award flight risk, and you're being told that the second, third, and the fourth respondents are flight risks. Yeah, the machinery that the prosecution has, and this word has been used severally by prosecution, reduce the risk. You have powers to confiscate the trial documents, Your Honor. And also making an application for the respondents to report to the IAO at a time, day, and duration. Your Honor, at paragraph 6 of the said document, the IAO speaks to a doctor's report. Which he says Through an X-ray, MRI, which is leaving all of us to assume what that means. The MRI of a deceased that he suffered blunt abdominal trauma and traumatic bladder injury. In your honor, no report has been annexed to that document. The document that is referred to as the supporting affidavit. You know, we are also being treated to given, no gender is given. So we are left again to speculate that there is somebody, a person called a person who is at large. And you're being convinced that the 21 days they are seeking for, they'll be able to produce the nameless person to record their statement. Your Honor, we need to ask ourselves a question that the deceased, and we have been told that the deceased was a police officer, may so rest in peace. The main reason why we are asking this honorable court,
you need to ask ourselves a question.
Yes, my lady.
Yes.
We are coming to the question.
Yes.
You've interfered with my thought process.
Also, it's a question mine.
My lady, the deceased person was a police officer. Now the prosecution is convincing the honorable court that they need 21 days for the accused persons to continue being held in custody. So this is where the question comes in. Being a police officer, with the current emotions that are going on, is the safety of the second, third, and fourth respondent specifically, and all the respondents generally assured. Your Honor, the court needs to protect the respondents so that we do not face another injury or death. Your Honor, the accused persons, second, third, and fourth, suspects, and more specifically, the fourth respondent is a responsible family man with a young family. In fact, the wife is present in court this afternoon. The fourth respondent has a fixed abode, which the prosecution has also captured in the document supporting the affidavit, that they arrested him at his house. Therefore, they will not leave the jurisdiction of this court until the case is heard and returned. Yona, he is ready. They are ready to report to the IO if need be. And we need to submit also that the fourth respondent is gainfully employed, as a disco jockey, and both the second and the third respondents work with him. Second and third respondents. Yona, we also wish to point out that as we approach the Easter holidays, the fourth respondent, through his trade, has executed several contracts to perform and entertain and bring happiness to revelers during the Easter holiday as we celebrate Pasaka. You know, we appreciate at this juncture that the respondents are facing serious crime of murder, but under Article 49(1)(h), the right to bail pending trial, irrespective of the gravity of the offense, they have a constitutional right to be presumed innocent until proven guilty. In conclusion, Your Honor, we therefore implore this honorable court to admit the accused, the respondents, to bail pending trial, and they're ready to submit themselves to any other conditions that the Honorable Court may grant. Lastly, before I yield to my learned friend, we would implore the Honorable Court to give an order for the release of motor vehicle registration number. Yes.
That application now comes
Yona, that motor vehicle has not been captured in this document. It is not part of the investigation. If it was, the Honor.
Address me on the issue of the accused persons, or rather the suspect being remanded.
I stand guided, Your Honor.
Yes. can make the issue, can make a formal application to address the vote on the issue, which has not been mentioned.
It has not been mentioned in this document. Yes, Your Honor, as my learned counsel have submitted before me, we wish to request this honorable court to grant the prayers that we have submitted on. Unless the honorable court has any questions for me, we wish to yield to my reply. Thank you.
Is another council submitting on behalf of the second, third, and fourth?
No, I think.
We're done with second, third, and fourth
Yes.
aspects. Then we go to fifth and sixth and seventh respectively.
Thank you very much, Your Honor. Your Honor, the 5th, 6th, and 7th respondents, Nyambo,